Hi, everybody. I'm Diane Brady. I'm speaking with Mike Quinn, who is a partner at Eisenberg Baum, and we are speaking about the recent Supreme Court ruling that is impacting the opioid settlement in bankruptcy court that was struck with the Sackler family, during which, of course, was related to their ownership of Purdue Pharma, which has declared bankruptcy. Nice to see you, Mike. Thanks for joining us. Let's first talk about your interaction in this case, who you represent and why.
Sure, and thanks for having me on today, Diane. So right now, the U.S. Supreme Court just granted certiorari to hear this monumental case. And for this part of the case, I'm representing an individual who has been along in the appellate process this entire time. Her name is Ellen Isaac. She lost her son, Ryan, in November of 2019. He died of an overdose locked in her bathroom in her apartment, and she wasn't able to resuscitate him. So, you know, like so many people in this case, the gravity is it's a very grave situation. During the bankruptcy, I represented other individuals, including the artist Nan Golden and activists from across the country who are really concerned about getting accountability in this case from the Sacklers. So we've been at this for years, and we'll continue to fight it. We'll be preparing a brief for Ellen.
What I find fascinating about this case is it's no easy, and this is the Solicitor General of the United States in some ways versus several attorneys general who had signed off on this deal. Is the problem right now seems to be that it is being decided in bankruptcy court. Is that, to you, the heart of the issue?
The heart of the issue, and like you said, the states' attorneys generals have all signed on to this settlement, so they've consented to the settlement. What the Solicitor General is fighting for are those individuals who won't be able to go after the Sacklers, but don't consent to the settlement. So they're losing their property right to sue the Sacklers for the harms that they caused. And so that's really the issue, and it's been a long-standing issue that the U.S. Trustee's Office, which is part of the DOJ, has been fighting against.
So the deal that was struck, I believe, is about $6 billion. And one thing that I'm curious about, we are in a relatively conservative Supreme Court. I don't necessarily want to guess how they'll rule on this, but at the very least, this certainly delays some of those payments that could have been handed out relatively soon. Is that, you know, for a higher cause worth the wait?
So I think, first of all, we're very sensitive to especially individuals getting paid out. You know, we do want individuals to recuperate if they choose to. But the way that the deal was struck, there's no opt-out provision. So I get emails every day from people saying, we just want to go after the Sacklers. You know, whatever happens financially is secondary to us. You know, they have more than a pecuniary interest. They're seeking accountability.
Which is interesting, which is a good point. This is a civil settlement. There have been no criminal charges against either, you know, the former CEO or any other member of the Sackler family.
Yeah, and it's really a shame because the Purdue Pharma as a corporate entity pled guilty to 2 crimes a few years ago: bribery, kickbacks, and stealing money from the government through Medicare, Medicaid issues. But they did like the government is fully aware who these individuals are that committed the crimes, but they haven't brought a single charge against an individual. And so, you know, U.S. Attorney Selinger from New Jersey is the government attorney in charge of the criminal cases, but yet they've just sort of sat on their hands. So a lot of my clients are you know, regularly protesting and advocating for him to move and indict, for example, Richard Sackler. You know, Maura Healey, the former attorney general from the state of Massachusetts, said that she's seen the evidence. It's clear that there was illegal behavior, you know. And then again, these corporate charges, like clearly it wasn't a driverless machine. There were individuals committing those crimes. Yeah,
it's interesting because it does feel almost existential in some ways. You know, corporate leaders, and you know, corporations are not people, but corporate leaders rarely are charged criminally for the behavior of their companies. We've seen it during financial crises. We've seen it, in this case in particular. How optimistic are you that in the absence of this settlement, that there would be some criminality or some degree of this playing out in criminal courts?
Yeah, I'm not very optimistic because, like I said, the information is available to government officials. They just haven't acted on it. And so whatever's going on behind the scenes that they're sitting on, they're just not doing anything. And in fact, like our position is that this bankruptcy itself is obfuscating the ability to go after criminal charges. Not to get too deep into the woods, but in the criminal pleas against the corporate entity, the company pled guilty to these crimes, but those crimes haven't been entered into court. And so Purdue has been existing while being a known criminal for years after the former administration announced the crimes and announced the settlement. It's really peculiar. And if you read that criminal information, it says that this settlement is contingent on a bankruptcy plan. So somehow they've tied the criminal side to the civil side. And that's very upsetting to my clients.
What does a win look like, Mike? I mean, there's a philosophical issue here. There's also the literal, damages and how they get paid. For your client or somebody, I think I've heard you say you felt like the Aaron Brockovich of the opioid crisis at one point, because I know that you were, at times, a lone voice. What is an optimal outcome that's realistic?
Yeah, so I think it's accountability, to hold individuals accountable, because otherwise this is just a roadmap for future mass tort crimes, And secondly, we don't disagree. The resources should be distributed to the individuals that were harmed in these cases. So we're certainly not against a financial resolution. And I could be very nitpicky about particular parts of the plan. We're not really focusing on that. What we're focusing on right now is doing away with these third-party non-debtor releases, because it just incentivizes business owners and decision makers to act recklessly, because they'll always have an escape hatch. They'll always be able to throw the entity into bankruptcy and piggyback right along with it and limit their liability in a very proactive way. We don't think that that's just, and we don't think that that's what the bankruptcy system was set up to do.
Help me look around the corner a little bit, because I think obviously this is not what the bankruptcy courts were initially designed to do. Given what you know about the Supreme Court, whether through doing amicus briefs or anything else, let's say that this is struck down. What then? Did we go back to the drawing board, or in your experience, what would be some of the alternatives besides accountability? What does the next deal possibly look like if bankruptcy court's not an option?
Well, we certainly hope that, the Solicitor General is taking on this case. We hope that it emboldens the Department of Justice and they do pursue criminal charges for individuals if this is overturned. Secondly, we think that this is just the first layer of a series of negotiations that Purdue and the Sacklers have. They're not just going to walk away and say, never mind, come and sue us. They're going to come up with another number and another structure that maybe isn't as advantageous for themselves, but that there could be some sort of resolution.
Is there an urgency in your mind to this? Like, there is always that, speed versus depth. And is this a case that has to be resolved fairly quickly, or do you think that it's okay if it takes another few years to get it right?
Well, the Purdue and some of those advocates on that side of the argument are saying, geez, we got to get this done fast because we have to get the money to the victims. We're actually in favor of it. And it's like, okay, well, we've been talking about this issue of non-debtor releases since you filed this bankruptcy. And we've been saying this is not a good tactic. There's constitutional issues. It's not statutory. Like, deal with this now before it has to be dealt with in 3 or 4 and 5 years. And, you can't just cram a plan through based on faulty law and then get upset because there's no immediate conclusion. It's not like this is an issue that has sprung up late in the game. It's been briefed out. Yeah.
Well, and to your point, there are many players in this game, and I'm curious about some of the analogs. I mean, if we're talking about, alleged villains, we've had consultancies, we've had, other drug distribution companies, et cetera. Will this impact their liability in your mind? Because in essence, mentally, people almost felt like we'd moved on from the opioid crisis, that deal was done. Now we're focused on fentanyl and other challenges. Are there others who need to be held accountable, or do you think the Sackler family is unique?
First of all, this case has been reported on for 20 plus years. I had a client named Ed Bish, whose son Eddie passed away in 2001, and he attended the first congressional hearings on Purdue Pharma. This is a slow build, and, everybody does lose patience, but over time, more and more information has been disclosed about what exactly is going on. So I don't think it's ending anytime soon. The McKinsey stuff, like you mentioned, the consultants, came up during the bankruptcy, but they had been working on it. The issues we discovered were from 2014, 2015, so they were already a few years old. I think that if you unveiled the whole process, you would see a lot of dirty hands in this, because it went right from the manufacturers, the distributors, the providers, all the professionals that assisted them, all the consultants that assisted them, the insurance company, and then there are all these special interest groups that influence Congress. Richard Sackler famously said, I could get any congressman on the phone within 36 hours. This was a major structural issue. It was insipid throughout every body of government, every law firm. It's never ending.
Well, it is exhausting, I'm sure, and it's heartbreaking. This is a human tragedy first and foremost. And one of the things I'm thinking about is the money question. $6 billion was hailed as a victory because it felt like a lot of money in the context of the Sackler family and what on a monetary basis alone. Are those fines sufficient?
Well, they weren't fines; they were a settlement.
Or settlements. Forgive me. You're right. I misspoke.
Yeah. It would be nice if there were criminal fines against the Sacklers. There haven't been yet. But the way it's structured, there was a report filed in the bankruptcy during the confirmation process that showed that essentially the Sacklers wouldn't be losing any of their principal assets. Their payments that are structured to be made over 18 years would just basically be interest on the money that they already own. So they're certainly not losing any money that they've made off of selling opioids. They're just not, maybe gaining the interest that they would have otherwise had.
What is your message, Mike? And I know you're not, you're standing for some clients. I'm not going to make you obviously the voice of everybody, but are you hearing, from others who are involved in this case? There must be some who are disappointed that some of the money now may be slower in coming. What's your message to them? Or are you hearing that? Am I
Originally in the bankruptcy, there was supposed to be this emergency fund release of $500 million, way before there was ever a plan, way before there was ever a settled negotiation. That money never made it to help deal with the opioid crisis, and that was years ago. So money's been locked up for a very long time. We are sympathetic, and I am sympathetic to victims that would like, to get money to keep going. We certainly understand that, and we're not downplaying that. But again, these issues were front and center from the very beginning, and it's something that debtors counsel, creditors committee counsel, PI counsel could have resolved within the plan, and they just chose not to.
Yeah. Has any of the money been released on a meaningful basis? I mean, I don't know if you are even aware of that. I'm not sure myself.
No, not from this case, no. But there are other, there's big opioid cases.
There's multiple opioid cases out there. So what's on your radar now that you would put on ours, as we're watching this case and trying to understand the implications of how it unfolds?
Well, certainly I would pay attention to the pressure that advocates and activists continue to place on the Department of Justice to seek accountability of the individuals. You know, they really believe that people like Richard Sackler should be brought to charges. So I think that's something to pay attention to. And as that's running parallel, what happens in the Supreme Court? You know, the makeup of the Supreme Court, it's a fairly conservative body, and it's very complicated because on one hand, a lot of the justices are originalists. They follow the letter to the letter of the law. They don't breathe in a lot of interpretation into the law. And if you read the bankruptcy scheme, it's very clear that there's nothing in there about non-debtor releases. But conservative justices tend to be pro-business. And so it's going to be a conflict for them and their clerks to decide how this case pans out. You know, it pits some of their techniques along with business principles.
Is it a partisan issue? Like if there is a change to the Republicans, does that not bode well for the interest of a Solicitor General in continuing to pursue this?
Well, if you look at the deal from the last administration, the criminal deal from the Department of Justice, it was certainly, you know, fairer to Purdue and the Sacklers than maybe this administration. But we've already gone to a new administration, and there might be yet another administration. But all you can do is just keep fighting for the truth and fighting for accountability. And you never know when there's a sympathetic ear in the government.
Great. Well, listen, thank you for joining us, Mike. I look forward to continuing the conversation. And, you know, again, there's no win per se, but certainly accountability is the heart of this case. So thank you.
Thank you so much.